Hello, I'm Bill Peterson, Minnesota probate attorney. One of the issues that comes up frequently is how fast can the beneficiaries under a will or a trust get the assets or get their inheritance. Let me take an example. Let's say your father died last month. You know that you're in line to get a sizable inheritance. While you're saddened by his death, yet the inheritance actually could not come at a better time because you're behind on your mortgage and you need money to catch up on it before it goes into foreclosure. Now you talk to the personal representative, or sometimes called executor, and he tells you that it'll be at least another 6 months before all of the accounts, bills, and other obligations are sorted out and your dad's estate is distributed. Now you're anguished. Is there anything that can be done legally to get access now or in the very near future to that inheritance that, as circumstances have developed, you now need so desperately? Under Minnesota law, there are at least 4 ways that you can get part of your inheritance or have access to estate assets before the estate is wrapped up sometime in the future. First of all, there is the family allowance. If you were financially dependent on your dad for your livelihood, or if your mother is alive, there may be available up to $1,500 per month for living expenses. Secondly, if it appears that the estate will have sufficient resources to pay off all of your dad's financial obligations, the personal representative can decide to distribute cash advances to the heirs of the estate. Now, a personal representative is sometimes reluctant to dole out advances because, well, you can have unknown bills, or there can be future fluctuation in the value of assets. And these can sometimes turn a sizable estate into one with very limited assets. Believe me, no personal representative wants to go back to the heirs and ask them to refund advances on inheritances that the personal representative had previously given them. Now, a third way to get funds from the estate is by a claim on the estate. This can happen if you've loaned some money, for example, to Dad, or if you did some work or gave your dad some items of personal property. In this case, you may be able to make a claim on his estate that the personal representative may have to pay. Now, claims by family members against a parent's estate are sometimes viewed with suspicion by personal representatives or by the probate court. But it is one more way that you may be able to get some cash from the estate before the estate is finally wrapped up. A fourth way to get cash is to get a loan, usually from an inheritance funding company, and then what you have to do is assign to that company part or all of your inheritance. Of course, the company wants to know that your inheritance is virtually certain and that there will be sufficient funds to pay the assigned inheritance when the estate is finally settled. Now, another disadvantage is that these companies usually charge significant fees for their services. When an heir needs funds immediately, or if an estate is not going to be closed soon, the heir can often get access to his or her inheritance, although it may come at a high price. Now, these are 4 options to get access to an inheritance or assets of the estate before the final distribution of those assets in the estate. Since a good deal of money and sometimes financial risk is involved for the heir before he or she can get access to a share of the estate, it's always wise to consult with an experienced probate attorney before selecting any of these options. I'm Bill Peterson, probate attorney. I'd be happy to talk to you about your family situation. Call me at 952-921-5818. We're looking forward to your call.